over. So as the President explained, we're going to begin with commencing proceedings, evidence management, and witness statements. And in this first segment, for which we've dedicated 50 minutes, at the end, we hope that you will be able to relate the commencement of proceedings to one, the overriding objective, to the duty of litigants to assist the court, and to the powers of the court ensuring a just and proportionate disposition of disputes. You will also learn about 3 methods of commencing proceedings that your rules prescribe, and you will understand the application of measurable performance standards to the management of the commencement of proceedings. The first thing that we need to speak about is that there is an onus on the litigant to select the appropriate commencement method. As I just explained, the rules provide for 3 methods, but the litigant has the responsibility initially to select which method they will initiate to commence proceedings. There are 3 methods, as I explained. The first is what is called a standard claim form, or just a claim form. Rule 8.15 speaks to that, and that's really the method that should be used for the majority of disputes. Then there is something called a fixed date claim form. 8.16 speaks to that, and that is the rules prescribe that is for the resolution of specified case types. Basically, this group of matters that fixed date claim forms address are matters where there should be no dispute of facts or very, very little dispute of facts, and where the disposition is likely to take a very short time. The rules provide for 3 examples: hire purchase and credit sales, money lending, and the possession of land. So if a matter falls into any of those 3 categories and there is going to be little or no dispute of facts, then they are appropriate for a fixed date claim form. Unlike some of the other jurisdictions, the draft rules include what was in your former rules of the Supreme Court, originating what we called originating summons, but it's now called an originating application claim form. And that's your rule 8.15 and 8.16. This, in a sense, there's a little overlap between this and the fixed date claim form, but when we go down a little deeper, we will understand, we hope, how they can be differentiated. But they are also intended to be used for the resolution of matters that do not involve a substantial dispute of fact. And in a sense, they can be used for matters involving children and matters that it is anticipated will have a very short time to disposition. So from this, you can see that but for standard claim forms, both the fixed date claim forms and the originating application claim form are intended for matters that should not include a big dispute of facts and should not take up a lot of court time. If for any reason the claimant initiates proceedings, commences proceedings using an inappropriate process, it's not necessarily fatal, because at a case management conference, or in the case of both fixed date claim forms and originating applications, at what is called in the rules the first hearing date, the court has certain case management powers. And so it is not likely or usual that a court would strike out these proceedings. In the case of Hannigan and Hannigan, it has been explained that there is an option to direct the modification of the form, that is to say, to treat the form as, say, a claim form, and to give directions for the continuation of the proceedings according to that. That way, the court does not waste time and continues to move the matter along in terms of the overriding objective to deal with the case justly. Original application forms. I'm just seeing the president back in. President, were you able to speak with Sir Dennis?
I spoke with him. He lost internet. He thinks he's gotten it back now, so he should be with us shortly. So I told him that you will continue. Well, you know, and he will. Great. When we see him, then he will take over.
He'll pick it up from there.
Yeah.
So original application claim forms 819-1.
It's actually originating.
Originating, yes. This should be originating. Sorry. The court may or may, so these are the rules that allow for modification and continuation. Court may, with or without an application, order the claim to continue as a standard claim form. So this rule, it describes what I just explained, which is to say that if for a reason a matter starts as originating application, but when it comes before the court, one discovers that the matter is more appropriate for a standard claim form, then it can, with or without an application, convert. A party, however, can also, at the first hearing, while Sir Dennis gets just sorted out there, a party may object and say, well, hold on, this is an inappropriate originating process because there is a substantial question of facts in dispute. And again, the court has power to give directions. So Dennis, in your absence, we've just done the preliminaries, really. Are you ready to continue?
Yes, I'm ready. I'm ready. Can you hear me and see me?
Yes, we can both. So I'm going to just move to the next slide and pass it on to you.
Before we go to the next slide, Peter, I just wanted to interject this thing. The originating application claim form is really to be used in circumstances, as they say, where there's not a substantial question of fact. The example I want to give, because I want to use that example later on, I think, is if, for example, you want to get a court order because Granny has Alzheimer's, Granny has a lot of assets, and so Granny can't look after her affairs, and you want to get a court order that somebody is appointed to look after her affairs. Now, that may not involve a substantial question of fact. You might just need a doctor who could testify to Granny's mental state and so on. And therefore, you would use an originating application claim form for something like that. But if your cousins are objecting, no, you just want your hands on Granny's money because Granny is really not, senile, and there's a substantial dispute of fact, then the court on its own motion or the other side may have that matter. As I said, the court has power to give directions and to continue the matter as if it were filed as a standard form claim.
Okay, yeah. So Dennis, this is where we've reached, and
okay, beautiful.
And so now we move on to.
I'm sorry that I was off a little bit at the beginning, but my internet dropped. It happens even there in St. Lucia from time to time. But let me carry on. It's important to recognize that once you've issued the writ, it must be served within 6 months. Of course, there's a power to get an extension of time, but that power is limited, as you'll see, by the rules. I've put up here for you rules 8.2. Now, one of the other points to observe here is this, is that one has to be, if one is caught by an approaching end of the limitation period, the time is measured at the date the court office receives the claim form. So that is when your time ends. Now, the court will allow you, if you're caught by surprise, the court will allow you to file without a claim form if you got legal advice very late and within 28 days of filing the matter. So the court will permit some support to protect litigants from being caught by the limitation of actions rule. Next slide. Now, you can bring more than one claim in a single claim form if those matters can be conveniently tried together. Now, this is an important consideration to avoid future difficulty if a subsequent claim is brought for matters that could have been included in that original claim. And you'll recall that there's a power to strike out for abuse of process, which includes relitigation of matters which have already or could have been adjudicated by the court. And there's quite a lot of case law on that issue. I referred to one. Now, a claimant is also required to make persons who are jointly entitled to remedy to be party to these proceedings. But failure to add a necessary party or adding unnecessary parties will not usually result in the claim filing. Now, a lot of these, I wanted to link a lot of these principles to the overriding objective of being just and proportionate. And you'll see that a lot of the rules addressing how proceedings are commenced observe and implement those principles. Next slide, please. Now, we discussed earlier in a previous session the general duty to set out your case in the claim form. So the party in commencing proceedings, you must file all relevant facts on which the claimant relies and identify any document that is known to the claimant, which the claimant considers to be necessary to his or her case. And if property is being sought to be recovered, the claimant must state an estimated value. Now, remedies must be stated. Remedies sought must be stated. Although the court may grant a remedy to which the claimant did not claim if there was an entitlement to it. But there must be a statement of claims for aggravated or exemplary damages. And if you're claiming interest, it must be stated, and the basis of the entitlement, the rate of the interest, and the period for which it is claimed. If one is claiming a specified sum of money, the total amount of interest claimed to the date of the claim and the daily rate at which it will accrue after the date of the claim must also be stated. Now, these are matters which may affect your ability to obtain relief from the court. So care must be taken at the time commencement proceedings are commenced to understand these rules and apply them faithfully. Now, a very important point here is that every statement of case must be verified by a certificate of truth. And that is prescribed by Rule Part 3.8. You will notice that throughout this slide, although I might not be stating it all to save time, I've put in square brackets the relevant part of the rules which set out what I'm speaking about. Now, the certificate of truth is particularly important because it replaces or there's a type of affidavit, and there's a level at which the statements within the claim form represent an assertion or to the court that of the truth of the matters which are stated in the claim form. So again, the obligation to justice is clear when one is completing your claim form. Now, there are special requirements for certain types of cases. And most important are personal injury cases. Part 8.9 requires the claimant to state the date of birth. If evidence of a medical practitioner is intended to be relied upon, a copy of a report from the medical practitioner must be attached to the claim form. Although, of course, you can call additional evidence at the trial. And a schedule of special damages must be included or attached to the claim form or to the statement of claim.
Chief, if I may interject at this point, one of the things that I have found in relation to the rules is that they are very sensitive to the time of medical practitioners, so that particular rule for personal injuries claims allows for the medical practitioner, their report to be attached to the claim form. And if both parties agree that that is the report, then there may be no need to call the medical practitioner to give evidence.
Okay. Another special requirement is that if you are bringing a relator claim, and the consent of the relator must be filed before the claim is issued. And that is also in keeping with the principles of the overriding objective. Now, we re-emphasize the thought that in complying with the duty, the general duty of setting out one's case, whether the rules provide for pre-action protocols or not, there is a desirability and advantage to be gained from pre-action communications, which can prevent unnecessary litigation, can get settlements, can limit issues for trial, and may even provide support for the litigation success if it's necessary to continue. For example, one could agree on electronic service or other matters of administrative convenience for the conduct of the proceedings.
And I think, Sir Dennis, what we're trying to say here is that whether or not you all go for pre-action protocols, please encourage pre-action communication at the minimum.
Now, this is just a repeat, a re-emphasis of the duty to set out the case. I've spoken about that already. And we can move on to the next slide, the next two slides. Now, one of the important points to remember, to bear in mind, is that you recall that the overriding objective sets out a number of principles that will assist in the just resolution of the case. And one of the ways in which the commencement of the proceedings implement that principle of justice is that the rules require that the claimant must serve with the claim form a defense form that is appropriate to the case. They must also file a form of acknowledgement of service which guides the defendant to indicate whether and to what extent there is a dispute about the claim. Now, if the claim is for money and there is an admission of the liability to pay, there must also be filed with the claim form an application form for the defendant to pay by installments. And the claimant is required to put on the document served the information necessary to assist in the return and the filing of the documents. Later on in this presentation, I will exhibit some of these claim forms that you could expect that the rules will prepare for you to serve on defendants. Now, I just put these thoughts together. These are not intended to be exclusive, but it just sort of pulls together some of the principles within the commencement of proceedings, which would tend to support the overriding objective. The requirement to state facts and identify documentary evidence is a key factor with dealing with a case justly and proportionately. It helps to narrow the issues, identify and narrow issues, and provide preliminary evidence of the claim. The requirement to specify the remedies and the supporting material also assists to narrow disputes and to facilitate dispute resolution. The filing of the consent of a relator eliminates unnecessary factual disputes. The requirement to provide a certificate of truth reflects the duty of a party to be committed to truth and justice. The service of forms for acknowledgement of service defense and application for installment of payments is a key part of disposing of cases justly and appropriately. And it takes away a little bit of the adversarial nature of commencing proceedings, because it sets a tone for different types of resolving the dispute between the parties. The parties of the court are able to determine what, if any, issues are in dispute, narrow the issues that are in dispute, and move towards just, expeditious, and proportionate disposition of the case. So these are the general thoughts of the principles set out in the overriding objective. Now, we have spoken already, and we will be speaking from time to time about the way in which the rules provide mechanisms to ensure that there's compliance with these rules by the imposition of sanctions. And some of these sanctions relate to the way pleadings with the claim is commenced. So for example, in part 26.22, the court has power to make orders of its own initiative. The court may strike out a statement of case that does not disclose a reasonable ground for bringing the action, and may make adverse orders as to costs. The court may make an unless order, that is, an order that compels compliance with a rule for which no sanction has been disposed, and would normally imply a term that if the order is not complied with, the case will be dismissed. But on the other hand, the proportionate aspect of the rules gives the court power to grant relief from sanctions under specified circumstances. Now, we don't go into that in detail today because we'll be dealing with that at a subsequent session. But these principles are set out in part 26, with which it's important that practitioners should become very familiar.
So Dennis, just to let you know, it's about 25 minutes in, so we are about halfway in time.
Okay, thank you. You've got to hurry up now. Now, I just wanted to push the point that it's a just and proportionate exercise, that the court is required to exercise the power of sanction in a just and proportionate manner. And I give a few examples here. A claimant who failed to specifically plead and strictly prove special damages had the award set aside by the appeal court. I state the case. A claimant in a personal injury claim failed to state the date of birth and to attach a certificate of truth to the claim form, but attached the said certificate to the statement of claim. Now, there's an application to strike out, but the judge considered all the facts of the matter and dismissed the claim to strike out. There's a case that deals with that. Now, regarding the power to strike out, the power given by Part 26, Rule 3.1, the court may, as opposed to must, strike out. And that implies the obligation to consider alternative methods of dealing with the failure to comply. And in 26.125V, this would include the power to give any other directions to further the overriding objective. And that phrase is specifically used in the rules. And the court could order the complainant to supply further details within a further specified period and specify the consequences of non-compliance, which might include striking out. I state the rule where that is. Oh. There's also the unless order option provided by Part 26.41. Now, bearing in mind the court's power to make orders of its own initiative, a defendant should not be able to deprive the court of a more proportionate solution where applicable by making an application for the most draconian solution. And there's a case that deals with this matter. Incidentally, just by way of, I suppose, small talk, this is a Privy Council case from Trinidad, and Justice Jamada wrote the decision of the Court of Appeal. Now commencing proceedings include service. And the point I wish to make, you see I'm running out of time. It is important that you must pay attention to the details of the rules governing service. And this is in Part 5 and the practice direction. Now, the claim form and the statement of claim must be served together unless there's special dispensation given by the court. Now, what's important to recall and why the attention to the details of the rules is so important is that there are specific rules for service and specified defendants. So you serve against an attorney of a party, a limited company, separately with different regulatory frameworks. A personal service must be proved by affidavit of the server with adequate proof of identification as set out in the rules. And electronic service is proved by the affidavit of the person responsible for transmission with specified exhibits, or even by an electronic confirmation of delivery as set out in the rules. Service out of the jurisdiction is also full of detailed regulatory framework. Now, counsel should become familiar with the conventions relating to the service of documents out of the jurisdiction to which Bahamas is a party. There's a general power to serve outside of the jurisdiction without the leave of the court. And the rule lists all those circumstances where that may occur. But it identifies situations where leave of the court is required and the method by which application should be made. Now, the rules also specify that if service out of the jurisdiction is protested, and the standard and onus of proof is clearly placed on the serving party, because the rules say that the court must dismiss proceedings unless there's a good arguable case. And that's a standard and burden of proof. I think that I don't need to go through these details, but except to emphasize the importance of paying attention to the details set out in Rule Part 7 for service outside of the jurisdiction. Now, the documents to serve in the claim form. I brushed over this a little earlier, but I think this is a very important part of the whole concept of linking the commencement of the proceedings to the overriding objective. And I've set out the rules which govern this on the PowerPoint presentation. When a claim is served, it must be accompanied by a copy of any order made regarding urgency or extension of time for service, a defense form, the acknowledgement of service form, and if the claim is for money, it must provide the application form for a defendant who admits liability to pay by installments. There must be inserted on each form the address of the court office to which the defendant is to return the form, the reference number of the case, and the title of the claim. Now, the claimant is required to find out whether there is a standard defense form that is appropriate to the particular case set out in a practice guide, and in practice guides that might exist. And the form sent to the defendant must be in the standard form that is appropriate for the nature of the claim that is made. Now, here are the forms. The instruction, I just want to do, Larissa, can you pull up this form briefly? How much more time do I have now, Peter?
You have about 17 minutes.
Oh,
I'm trying to open the form here. We embedded it, but it's not opening.
Right.
I will open it, Judge. I can open it.
All right.
Let me just.
You see, when the acknowledgement of service is completed, it gives the defendant the option to say whether.
If you let me share screen and pull it up.
You're putting it up now?
If I can share screen, I think Justice Jamida has to stop sharing screen for me to share screen.
Okay.
Go ahead, Larissa. I've stopped sharing.
Thank you.
Yes. You see, the form has notes for the defendant. And it tells the defendant what action can be taken on receipt of the form. Now, and it explains that what will happen to the defendant if the defendant does nothing. But it sets out how the defendant can defend the claim if the defendant wants to do it, wants to defend. And it sets out the process that must happen. Could you go down to me, please? No, but it says also that the defendant can admit the whole of the claim. And it explains how to do it in terms of what entry must be made on the acknowledgement of service. And it advises the defendant that they can pay the amount stated on the claim form, but that if the defendant cannot pay the sum in full, the defendant may apply to the court to pay by installments. So this is a step that can be taken immediately after the claim form is received.
So Dennis, there's a question in the chat concerning the requirement of claimants to serve documents dealing with payment by installments. Does this not allow abuse by disgruntled defendants who are able to pay the debt in its entirety, but seek to punish claimants by making them wait for installments?
Well, the answer to that is simply is that the defendant who makes the application doesn't make the order. As you'll see later on, the defendant is required to provide evidence of means backed up by a certificate of truth. And the court will then have the opportunity to interrogate, and the claimant can also provide evidence to the court, which will assist the court in making a fair decision. So let's move down quickly. I think we've made the point.
Do you want to look at the other forms? Do you want to look at
yes,
anything?
the acknowledgement of service and the application to pay by installments.
Okay, so can we pull up the acknowledgement for service first, sir?
No, Judge.
You see, the benefit of the application for employment installments is it allows the court, it saves a lot of time because it allows the court to enter judgment then and there. And it saves all of the process of applications for judgment summonses and that sort of stuff. So you have this ability to interrogate the means of the defendant immediately after the acknowledgement of service is filed. So it expedites the process of getting the final judgment and getting orders, compelling orders to pay. Now,
We have
sorry?
No, I'm saying you have the acknowledgement of service form.
Yeah, here it is. Yeah. So you see what it says here specifically. And let's go there very quickly. It asks the defendant, have you received the claim form? If so, when? Did you receive the statement of claim? Are your names properly stated? Do you intend to defend the claim? Do you admit the whole of the claim? Do you admit any part of the claim? If so, how much? You may pay the money, or if not, you can complete an application to pay by installments. And then it gets evidence to facilitate the continuation of the proceedings. So let's look quickly at the application to pay by installments. Yes, there's a question in the chat room, where can one find the relevant claim forms? Now, these forms will become part of the rules. The rules which have been exhibited are still in draft form, but the section of the rules which deal with forms will be added. And these are the rules which I collected these from what is applicable in the Eastern Caribbean. So these are the rules attached to the CPI in the Eastern Caribbean, and it's most likely that something like this will be attached to the rules in Bahamas.
And then, so that's just to add, throughout the region where this applies, these forms are both basically standard forms.
Yes, yes, that's true. Now, for the person concerned about the fairness of the opportunity to apply to pay by installments, you see, the applicant has to acknowledge the debt. Then the applicant indicates how the offer for payment, and then now the information upon which the court will exercise its discretion, which could be challenged by the claimant, is set out. What's your marital status? What is your age? What are your dependents? Are you employed? What kind of employment do you have? Give particulars of annual receipts of the business. Give details of any other job that you might have. Give details of contracts and other work in hand. Any sums due for work done. If employed, how long employed? Are you a pensioner? List your cash assets. Do you live in your own property? Jointly owned property, rented property? What is your usual take-home pay? What your pensions is? What is your other income? What's your total income? And then there's a provision where you set out what are your regular expenses. I don't need to go down the list. But
Larissa, just scroll to the very bottom.
Yes.
Right. Okay.
Yes.
So it's very detailed.
Very detailed. So a defendant who wants to play tricks exposes. There's an exposure to being, found out if the truth is not explained, set out in these forms. And this is exactly the process that you would go through if your defendants don't have property that you can seize, and you apply to the court for a judgment summons. But it's an improved way of getting the judgment summons proceedings through at the very beginning of the proceedings in appropriate cases.
So Dennis, we have 8 minutes left. Shall we resume?
Yes, please. Yes, please.
All right.
Let's go quickly.
Let me just get the screen up to share. All right, good.
Now, the original application form. Now, this is also a very important form because it can be used when the court's decision is being sought on a question which is unlikely to involve a substantial dispute of fact, or it's required by a statute or a rule. And it can also be used where there's a claim by or against a child or protected party or patient, which has been settled before the commencement of the proceedings, and the sole purpose of the claim is to obtain the approval of the court. So you'll see that this is, you've seen the standard claim form, the fixed date claim forms, and now you have the original application form, which is something which you can get before the court. Let's go down, case management. You can't get a default judgment, but if there's a failure to acknowledge service, the defendant is not allowed to take part in the hearing without the permission of the court. And the court may, on its own application, direct or continue the matter to continue as a standard claim form. And it must fix a hearing date and give other directions for early disposal as soon as a defendant has acknowledged service. Next slide. Now, the form must contain the question that the court is asked to decide, the remedy being sought. Now, you ask what type of proceedings is brought under the original application. And President Saunders gave an example again. And I set out another type of proceedings here, where a person seeks a direction from the court to deal with the management of a trust or a will and that sort of stuff. Now, in some of these cases, there's no defendant. And in such a case, the court has the power to set the matter down for hearing the day after it is filed. Now, let's go down to the next slide here, because
you want
evidence management.
Do you want to move to this? You want to go to the
No, just quickly, evidence management. The claimant is required to file the evidence with the claim form. And the defendant, if there's a defendant who acknowledges service, the defendant must file the evidence with the acknowledgement of service. So the matter is read for hearing in 14 days. So the court so this is a matter which can come on for hearing very quickly. Now let's move on to the next slide. Now, we prepared a flow chart here for the claim form, which shows you the way how things should work and the time frame within which it should work. So if there's any pre-action protocols or communication, the first milestone is the filing of the claim form. And you'll see the steps that goes. You file the claim form, you serve the claim form, you file affidavit of service. The second milestone is the entry of acknowledgement, which takes place 14 days after the service of the claim form. And that involves the further action. You notify the claimant, you file application with declaration of disputes, and you file and serve the application to extend if necessary. The third milestone is the defense, which must be filed within 28 days of the service of the claim form. You see? And you can file a counterclaim if you want at that time. And then the fourth milestone is the defense, reply to defense, which must be filed 14 days after the service of the defense. Now, the main point here is this now, is the first case management conference. Now, I put down 84 days here as a standard because what the rules actually said, that the first case management conference must be heard not earlier than 28 days after the defense, or more than 84 days after the defense. So there's a standard set in the rules that your case management conference must fall within 28 days of the defense or 84 days of the defense. And we set out some other little statistics here, which would show the type of performance measures that the court office should take into account. And which also shows you the pace at which cases are expected to be concluded under this new system. Now, the fixed date claim form is even quicker because on the filing of the claim form, the court office is required to give a hearing date. Now, then after that, the defendant files a defense an affidavit, and then the first milestone really is the first hearing.
And
now you might ask
Dennis, that must happen within 28 days. So
Yes.
within 28 days of service, the evidence of the defendant is supposed to be in.
Now, the point I was getting at though is that the first duty here now is the duty of the court office. Because when the claimant brings in the claim form, the court office must state on that date when the first hearing is to take place. Now, the rules do not regulate specifically. And I checked the practice in the Eastern Caribbean, which is being based on directions from the Chief Justice, that the fixed date claim, the court must issue a date on the same day the matter is filed. So the court office cannot delay in the giving of a date for hearing. Now, I had made some calculations here as to what might be reasonable and how you can calculate, create a formula for calculating when the date should be fixed. But in the Eastern Caribbean experience is that this is governed by instruction from the Chief Justice. And the registry is required that the first hearing date must occur within 6 weeks of the date of the filing. So whereas I have down here the first hearing date as 48 days, 42 days. 42 days is the outside limit. The court office must fix the first hearing within 42 days. Now, again, this is an issue which I think is going to require measurable performance standards, because at the first hearing date, as I made inquiries from the registry and a judge in the Eastern Caribbean, there is a percentage of cases which are disposed of on the first hearing date. Now, the percentage is not high. It's between 5 to 10% of the cases which are finally disposed of within 6 weeks of being filed. Then there is a percentage of the cases which are going an issue of partial or whole admission of liability, which requires certain directions which are dealt with as though it were a case management conference. But I was told that all of the other cases are then sent to mediation. And then after the mediation, there's a percentage of cases which are disposed of by mediation. And the remainder of cases come before the court for hearing. And the court then has a case management conference, narrows issues, and moves towards disposal. And again, the information I got was that all cases are heard, completely disposed of, within 18 months of the date of filing. So the court office with which, and let me be more specific, the court office with which I consulted was an Antigua. And the judge whom I spoke told me that they dispose of all of their cases within 18 months. So let's move over to the next one. Now, the same thing with originating applications. Again, you can also set standards, because this is a matter which is expected to be quick. If there's no defendant, if the application is filed without, and as President Saunders mentioned, there are many cases where that could occur, then the court can set down the matter for hearing the day after the application is filed. Now, if there's a defendant, and you'll recall that the claim must be filed with the evidence, the acknowledgement of service, if it indicates that there's an intention to defend, it must be filed with evidence. So at that stage, the court has the power to get involved in fixing an early date for hearing. So here you have proceedings where the court should expect that a fairly significant percentage of these matters are disposed of within a month after the matter has been filed. So as I'm wrapping up, I make the point that it's important for the court office to set and publish measurable performance standards. These standards will assist the court officers, the judges, and the registrar staff in knowing the standards to which they must comply. But it will also inform litigants and attorneys of the way in which these cases are going to be managed. And based on the concept and the overriding objective that the attorneys have to assist the court in managing the case appropriately, they will be expected to assist the court in meeting these performance measures. If this is done, a current complaint which has been made against the judiciary, because almost all the judiciaries before the CPR were complaining of delay. The commencement of proceedings, as you say, starts the ball off in a manner which sets the stage for an expeditious, fair, and proportionate disposal of the proceedings.
Dennis, we are a little over time, but this is such an important period. I think the President and I can make up a little time. If there are any questions that want to be raised, we can take about maybe 4 minutes. And there's,
I see some questions in the chat room, Peter.
No, I know they know. Yeah. Does anybody have something they would like to raise about this? The idea that you know, these different milestones and performance standards for the no. All right. Okay. So let's just press on. The next area we want to cover this afternoon, evening is the question of evidence management. And so Dennis has already begun to introduce this for us. I'm going to take you through this session. I'll spend just about maybe 25 minutes to try and come back on our time. But at the end of this session, what we hope is that you'll be able to locate evidence management in the context of the overriding objective, the court's duty to manage cases, and the court's powers under the CPR. We hope you'll learn about 5 overarching goals, 6 reasons why evidence management is important, 5 points that underpin evidence management, and 5 principles that underpin disclosure. And we also hope to be taken through a summary, maybe a quick summary of the rules that are relevant, and specifically about the 2 forms of disclosure under the CPR. It's important for us to say that all of this that we are trying to do in relatively short time periods require that you all certainly read the rules after these sessions and pay attention to the details of the rules, because it's very difficult to cover the details in these time frames. However, our slides have identified the relevant rules, so when you consult them, you can make the linkages and study them yourselves. Generally, disclosure and inspection evidence are dealt with in parts 28 and 29, so that locates us at the CPR. We think there are 5 overarching goals. First of all, evidence management is critical because it gives practical effect to the overriding objective, and so Dennis has already explained how commencement of proceedings gives practical effect to the overriding objective. So does evidence management. Evidence management also allows us to effectively and efficiently manage cases, to proactively explore possibilities for settlement, and where there is settlement is not possible, evidence management allows for the robust preparations for trial. Also very important and of great concern and interest to litigants, evidence management can minimize costs and reduce delay. So those are 5 overarching goals. And you notice we have called this little segment evidence management. We do that because we think that you cannot delink when in the CPR the idea of management. And how we deal with evidence is not simply what is admissible or inadmissible, but also how we manage evidence. So this is very intentional on our part. So those are 5 overarching goals. Why is evidence management important? We're going to give you 6 preliminary reasons. They're not exhaustive, and I'm sure you'll have many more, but these are at least 6 that we think are salient. No matter how good or true a case may seem to be, facts need to be established and proven. When I was a young attorney, I worked with a senior counsel in Trinidad called Sonny Mirage. And he used to work with another senior attorney called Russell Martineau. They used to work as a tag team, and they were both mentors to me. And Sonny Mirage used to tell me, Russell Martineau, he used to call him Dan. He says, well, Dan is all about the law and the law and the law. Let me tell you something. If you don't have the facts, you don't have a case. So he'd make a joke and say, look, forget about Dan and all the law, you know. You get the facts right and you've won your case. Let the judge worry about the law. Well, that showed you Sunny Miraj's bias. But the point is well taken. Facts need to be established and proved. Another reason why it's important is because, of course, evidence must be admissible and relevant. That is central to what we do as fact finders and decision makers. And also very important is this under the CPR in particular. Judges and parties, remember in 1.2 of the overriding objective, there's a duty of the party to assist the court in the achievement of the overriding objective. So both judges and parties have a responsibility. What is it? To ensure the best, most cogent, and most credible evidence is received by the court. Why? Because we need this kind of evidence to deal with cases justly. The next three reasons we'll give for why is evidence management important? Because, and so Dennis made this point the last time we met, he's made it again. Evidence management exists in this kind of double relationship with issue identification. It depends on issue identification and it supports issue identification. Cases are issue driven. The CPR says the first thing under part 26, I think, is identification of issues. Relevance of evidence can only be determined after issues are clearly identified. So that's another reason why evidence management is important, because having identified an issue, without evidence, we can't deal with the issue. So it depends on and supports issues. Very important, and this was the old expression, trial by ambush. I'm sure we all know that. There's a lot of learning in the white book about trial by ambush. Proper and effective evidence management prevents surprises, adjournments, delays, and again, litigants are very concerned with this, unforeseen and unbudgeted costs. Evidence management that is effective, therefore promotes timeliness, certainty, fairness, and just dispositions. And I'm hoping, we are hoping that when you hear these words, timeliness, certainty, fairness, and just disposition, you are hearing the resonances of the overriding objective. Can you think of other reasons? I'm sure you can, but these are just 6 that we offer to you this afternoon. Some general considerations before I go to a little more detail. As I said, a case is determined on available and admissible evidence. 5 key points arise here. Evidence issues are to be dealt with justly. They are not exempt from that principle in the overriding objective. Judicial officers have a duty to proactively manage cases in relation to the evidence. So judges have a duty to get engaged. What are the relevant issues and what is the relevant evidence? Courts must use the court's powers to receive and use evidence. We're going to look at this in a little more detail, but you have many powers under Part 26. You have to use those powers effectively. Apply consequences, every direction and order. The application of consequences is critical to the CPR. And as the overriding objective has stressed, you need to explore the most expeditious, timeliness, and least costly options. So evidence is central to the adjudicative process, yes, but these 5 key points should, as it were, inform our decision-making, and not just our decision-making, but our approach, our attitude, that is to say, proactively manage, use the court's powers, apply consequences, look for the most expeditious and least costly options, how we deal with our judicial role and attitude. So, having done that, I'm not going to spend a lot of time on this. I put these slides in here so that when you review this at your leisure, you have the information to help you. I have highlighted in bold just the parts that I think support what I just explained. equal footing, saving expenses, dealing with the thing expeditiously and fairly, enforcing compliance. These are in the rules. I'm not making these up. The duty to proactively manage cases. This is a cultural shift. Here it is in 25.1. The court must further the overriding objective by actively managing cases. That's the language. Identify the issues at an early stage, etc. I've highlighted J. Ensure that no party gains an unfair advantage by reason of that party's failure to give full disclosure of all relevant facts prior to the trial. So here you see one of the duties to actively manage a case is in relation to evidence, very clear. And of course, as Sir Dennis explained earlier, how you can fix timetables, give directions, and very importantly, make appropriate use of technology. This is relevant when it comes to evidence. Part 26, the court powers. I spoke about court powers, and you have them here. I pulled out some of the salient ones. The court may direct the form in which evidence is to be given, and that it can be given in written form. The old tradition of giving evidence orally, under the CPR, you need to move towards giving evidence in written form. I'm not going to talk too much about this because President Stoner is going to deal with witness statements and he'll cover this. But you can extend and shorten time, and you can receive evidence by telephone or use any other method of direct oral communication. So make use of your technology. And then, of course, the catch-all, again, Sir Dennis pointed to this. This gives the court tremendous breadth of powers. Take any other step, give any other direction, or make any other orders for the purpose of managing a case and furthering the overriding objective. So judges, you have enormous powers to be exercised in accordance with the overriding objective, and they are relevant to the management of evidence. The court's powers continued. You can act on your own initiative, and this is something that we want to stress over and over. The court's powers in cases of failure to comply. What does it say? The court, when it makes an order or gives directions, uses not a may, but a must, wherever practicable, specify consequences of failure. So this should be a routine thing. Whenever you give a direction, whenever you make an order, specify consequences of failure. This is part of the discipline of the CPR. Moving along now to disclosure and evidence. We think there are 5 key principles, and this is getting a little bit more into the detail of evidence management. What are you required to disclose? All documents that are directly relevant must be encouraged and compelled. So we're going to come back to look at direct relevance in a moment, but the principle is all documents that are directly relevant must be encouraged and compelled to be disclosed at the earliest opportunity. We've made this point, pre-action protocols, the identification of documents in pleadings. You remember Sir Dennis spoke about in commencement of actions, you have a duty to identify the documents you rely on, the evidence you're relying on, and early consequential orders for standard disclosure, come to this in a minute, promote just disposition. So these are 4 principles that we think are important. We continue to talk about pre-action protocols, but certainly identification of documents in pleadings, consequential orders for standard disclosure are very important. On standard disclosure, we think a key approach should be to routinely order standard disclosure at the earliest opportunity. And for that, we mean either at the first CMC or the first hearing. Remember when we looked at fixed state claim forms and originating applications, the rules don't talk about a CMC, they talk about a first hearing at which a judge has CMC powers. So standard disclosure should be routinely ordered at the first opportunity. And we say there must be time bound with default consequences. In other words, make standard disclosure on or before, and in default, say what the consequences are. That should be a standard order.
Just give it a time check. We're halfway.
Yeah.
Yeah,
Thanks a lot, Larissa. The fourth key principle under disclosure is the continuous duty to disclose. The rules provide for this. We'll see it in a moment. This is very important. There's a little question about this in terms of its application, which I'll highlight. But for the moment, have it disclosed once, that's not the end of your duty. You must disclose from beginning to end. And finally, the fifth key principle that we want to share with you is that the rules provide very serious consequences if you default. These include that you may not be able to rely on certain documents and evidence, and or parts or all of a case can be struck out. So with those 5 principles, let's look a little deeper at some of what is required in terms of evidence management and disclosure. General principle is what is to be disclosed is direct relevance. There was a time when the Peruvian guano case determined disclosure. The rules specifically say the rule known as the rule in the Peruvian guano case does not apply to make a document directly relevant. And I've set out in the fine print what that is. I'm not going to labor it. All the judges and practitioners, I'm sure, know this because you're practicing in the courts. But here's what's relevant to us. A document is anything on which information of any description is recorded, whether in writing, electronically, or however. So this is very broad. That's what a document is. Disclosure means revealing that a document exists or has existed. So it's not just what you have, it's what has been in existence. And for the purpose of this part, a document is directly relevant if, this is important, party with control intends to rely on it. So if you intend to rely on something, it's directly relevant. If it tends to, pay attention to the words, adversely affect the party's case, it's directly relevant. If it tends to support another party's case, it's directly relevant. So in any of these 3 instances, a document as explained, as defined here, must be disclosed. And that means a document that exists or has existed. What is the scope? Basically, this is talking about who had or has control. A party's duty to disclose documents is limited to documents which are or have been in the control of the party. So you see, it's about whether you have control, not just in the present time, but even if you had control in the past. But look at how they define has or has had control. Physical possession. If you've had the right to inspect or take copies of it, they say you've had control. If you had or have a right to possession of it, now pay attention to the word right. It's not whether you have possession, you know. It's whether you had a right to possession or a right to inspect and take copies. Of course, if you're in physical possession, then you are in control and you must disclose. There are 2 types of disclosure under the CPR, what is called standard and specific. You've heard those expressions before in this little presentation. Standard disclosure refers to all documents, we went through that, what does that mean? That are directly relevant to the matters in question. So whatever is directly relevant, all documents must be disclosed under standard disclosure. That's going to be very important because of what I said earlier. An early order, almost a generic order for standard disclosure at the first opportunity. So what does that mean? It means that at the first CMC or at the first hearing, when you make an order for standard disclosure that is time-bound and with consequences attached, very, very early in the process, you are going to get the evidence that is relevant coming in. But bear in mind, you can't really do that effectively until you identify issues. And that is why in the last session you had with us, we spent so much time on issue identification. And that is work that just has to be done because issue identification is in a way is the key that unlocks how we process matters. It leads to evidence management in this case. It leads to possibility for settlement, etc. Specific disclosure requires an order. It can be made with or without an application, and it can be made at a case management conference. Notice that specific disclosure also applies to documents that are directly relevant to one or more matters in issue. Come back to issues here. So what is repeated in both standard and specific disclosure, you see, are documents that are directly relevant to matters in question, to matters in issue. I think this language of matters in question in the rule and matters in issue, I don't know why the authors of the rule choose to use matters in question here and matters in issue here, but I think that they can be read as synonymous, meaning directly relevant to matters in issue, directly relevant to matters in question. Is the same principle. If there is an order for standard disclosure, and it is timely and specific with consequences, an order for specific disclosure should not really arise because you are disclosing the same things. But if on receipt of what is disclosed on standard disclosure, the court or a party thinks that, wait, hold on, there are some other documents that should be disclosed, then an order for specific disclosure can be made. But generally, we say the first order should be an order for standard disclosure. Now, having said that, at a case management conference, a court can make orders for specific disclosure depending on what is before them in the case. And this may be a more effective and efficient approach, a more proportionate approach that may save costs. So instead of having a carte blanche order for standard disclosure, if you prepare, you see the issues, you may say, if you remember the fish farm case when last we met, what we want disclosed are the expert reports that you, the defendant, had or relied on in relation to the toxicity in the water. That's the simple document we want now, not full standard disclosure. So even though I have said generally standard disclosure first, followed by specific disclosure, be flexible, because in certain cases, it may be that the first order you may want to make is an order for specific disclosure. All right, let's move along very quickly. What are the criteria? The basic criteria turn on fairness and cost. These are the overriding objective principles. You must have regard to benefits. That's why sometimes specific disclosure can be preferred, and the cost, and also the financial resources of parties.
Give you a call 5 more minutes.
Yeah, thank you. Very important to note is the duty of attorneys and parties. Attorney has certain duties, 28.8, to explain the necessity for making full disclosure and the consequences. What we want to tell you is this. You have to certify the list of documents. The maker, you must certify you understand and the duty has been carried out. All the certification that we spoke about statements of claim, about defenses, about acknowledgements of service, all of these certifications save time and cost because this is a form of attestation of going to truth, as Sir Dennis spoke about. Very important. Judges must make sure this is being done because at a trial, this can save a lot of time and grief, both for attorneys and for parties and for the court because there's certification. I have certified that these are all the documents, and then something pops up. It goes to credibility, for example. As I've said earlier, the duty is continuous. It continues until the proceedings are concluded, and there's a consequence. At any time during the proceedings, the party must immediately notify the other party of a document and serve a supplemental list. So that's what the duty is. But I'm going to come to another rule, which I think has a little matter of some concerns. You have a continuous duty, and once you get a document that is directly relevant, you must immediately notify everyone at the court and serve a supplemental list. What are the consequences? If you do not give disclosure on a date ordered, you may not rely on or produce at the trial the document not disclosed. So you can't use it. And a party may apply to the court for an order that the other party's statement of case or some part of it be struck out. So the consequences are twofold. You can't rely on the document, and your case or part of it could be struck out if the document that you have not disclosed is critical to the proof of that issue. In addition, disclosure is uses. Well, of course, you can inspect it and take copies. You can use the proceedings only for the documents only for the purpose of the proceedings. But very importantly, once a document is disclosed, there is a presumption of admission of authenticity unless you file a notice saying otherwise. So once you disclose your document, unless the party says otherwise, that document is authentic. And therefore, there's no need to prove truth because the authenticity is admitted, it's an admission. Finally, how is this evidence in the management to be given? Well, the court has control. Court can control how the evidence is given, what issues require what evidence, how it is to be proved. We explained to you that even though the general rule is oral evidence, 29.2.2 says the general rule is subject to an order of the court, i.e. to say that evidence given in a document or evidence given in writing can stand as evidence in chief, evidence in opposition, etc. I have just about, I think, 30 seconds. So as I close, and there's a rhythm to what we're doing because we started with commencement. We're looking at evidence management, and the president is going to take us a little deeper into this question of evidence and witness statements. But for the end of this little part, what I want you to reflect on, both as judges and as attorneys and as court administrators, registrars, and etc. What roles are you required to play to further the objectives and achieve the performance standards of the CPR? I think it is key when we go through the CPR and go through all of this evidence management, ask yourself, what role do I have to play as a judge? As an attorney, what role do I have to play? As an administrator or registrar, what role do I have to play? When we clarify our roles, that gives us the focus to sort of mindfully pay attention to a case, identify the issues, determine the evidence that is directly relevant, make orders that have time bound with consequences that can advance a case in a timely fashion to just disposition. So I say, as I close this little part that I am responsible for this afternoon, evening, is ask yourself, what role am I to play? President, I think that there are no questions in the chat that I see.
Judge, I see one question.
Sure, what's it?
There's a question in the chat asking about authorities that you would recommend, the Green Book or something else.
Authorities.
So they mentioned the Caribbean Civil Court Practice and the Green Book, and they want
there is a book. I don't know what the Green Book is, but there's a book authored by DeMambro and President Saunders. I believe the second edition is the last one in print. I don't know if it's been updated. That has certainly some up to the time of its publication, it was useful. Then there is another book published by, who is it? I sent it to Camille. Camille, do you remember the name of the book? Commonwealth Civil Procedure by Kundalini. Is it I've forgotten now, but Camille can drop the name in the chat for us. The Trinidad and Tobago JEI, when I was there, we published a consolidated version of our CPR, and for every rule, we supplied a list of Privy Council, Court of Appeal, and first instance judgments that were relevant to every aspect of the rules. So those are three resources that I am aware of. President Saunders and Sir Dennis, maybe you can add to that and bring others up to date. Camille, do you remember the name of the book that let me just see if I can.
Yes, I have it. I'm going to put it in the chat.
Oh, right, okay, I'm seeing it here. Gilbert Condolini and Vanessa Condolini, Commonwealth Caribbean Civil Procedure, 4th edition is the latest. So Camille will drop it in the chat. Thanks a lot, Camille. President, on to you.
Yeah, okay, thank you. Okay, so I'm going to deal with witness statements. Could you go to the next slide, just with the objectives, I think. So what we want to do is to locate witness statements within the context of the overriding objective and to provide you with a summary of the rules regarding production of evidence at the trial, and in particular, the nature and content of a witness statement. Could you skip this slide? And I'll just go to skip this one as well. Okay, so at trial, proof of facts must ordinarily be by oral evidence given in public. But it is also possible to prove facts by affidavit as part 29.2. When would you use an affidavit? Well, an originating application would be a good example of an instance where you use affidavit evidence instead of oral evidence or witness statements. Remember the example I gave about granny with mucho assets and a bad case of Alzheimer's, and you want to have her declared incompetent? You might use an affidavit to accompany your originating application. But whenever an affidavit is to be used, a party may apply for the deponent, the person who made the affidavit, to be cross-examined. Now, note that the general rule is if you're going to have a trial, you have oral evidence given in public. But that general rule is subject to orders of the court. And when there is to be a trial, the court usually, invariably, the court makes an order that the evidence is to be provided by witness statements. And that another important order, that the witness statements will stand as evidence in chief, so that all that the witness does is come up, take the oath or affirm, and say, yes, on such and such a date, I swore a witness statement, and that statement is true and correct, and that's my evidence in chief. Ordinarily, that is what would happen. Go to the next slide. We'll come back to the first couple of slides a little later. So what is a witness statement? Well, it's a statement of the evidence the witness wishes to adduce at trial. As I said, it's invariably ordered at the case management conference and ordered to be served and exchanged. Invariably, the court orders simultaneous exchange, and we will speak about the ramifications of that a little later. Witness statement has to be dated and signed with a certificate of truth. Again, you have the certificate of truth that comes in. It must be in the words of the witness as far as practicable. And in my own experience, I have come across some sometimes amusing, sometimes embarrassing incidents in relation to this, because counsel must faithfully observe this practice. The witness statement is not counsel getting the instructions orally and then the witness goes home and then counsel writes out a witness statement. No. I know of an occasion when a witness actually refused to sign a witness statement because he said that contained a set of big words that I would never use. I know another occasion when a witness, this was at trial, disavowed the witness statement he was hearing read back to him in cross-examination. And he said, no, I never signed that. And all of that was because of a miscommunication and a bungling of the process of preparing the witness statement, ensuring that it is in the witness's own words, having it read back to the witness, ensuring that the witness fully understands it before it is filed. Crafting of a witness statement is an effortful activity that actually takes a bit of practice. Some seasoned practitioners, after the rules came into force in the Eastern Caribbean, would confess to you that they have problems, they have difficulty in getting the hang of this witness statement business. It requires a certain degree of diligence. The witness statement must first of all identify any documents to which it refers. I know of another occasion when I think it was a running down action. There was a beautiful witness statement. The witness statement had identified and the witness had produced a number of documents, medical reports, receipts from the hospital and so on, but there was nothing in the witness statement that actually, by way of narrative, linked all of those receipts to the witness's evidence. And so what did the defendant do? The defendant steadfastly refused to cross-examine on any of those items of special damage, tiptoed right around that. And then at the addresses, he says, well, the special damages have not been proved because there is nothing in the witness statement that links all of these wonderful receipts and so on to the evidence. And I had to uphold that because there was nothing. There was a bunch of receipts, yes, but there wasn't anything that linked those receipts to the witness and the evidence that it is the witness who incurred those receipts and what those receipts were for and the like. Finally, the witness statement must not include inadmissible matters. So you can't put in a lot of inadmissible material, a lot of hearsay, well, you could put it in, but then at the case management conference, you're likely to be faced with an application by the other side to have struck out matters which are inadmissible. And in the early years, quite a lot of time and effort was spent on these interlocutory applications at case management to have inadmissible hearsay excluded from the witness statement. And sometimes that still happens. So if you could go back to the beginning slide now, the first slide. Sorry about that. So witness statements. What's the value of the witness statements? Well, first of all, the next slide, the one before this, they eliminate surprise. And you will hear us repeat ad nauseum this mantra about the overriding objective, about eliminating surprise during these training sessions. I grew up on a steady diet of Stanley Gardner. Those of you of my generation will probably remember Perry Mason. Perry Mason worked with a detective called Paul Drake. And invariably, Perry Mason was this wonderful lawyer, but many of the books, he would be trying this matter and Paul Drake would be investigating the incident and so on and getting clues and so. And on the last day of the trial, when you thought Perry Mason was dead in the water, Paul Drake would come in and say, I found this mystery witness who will clear up everything. And Perry Mason would put the witness on the stand and that would turn the whole case upside down. Well, that ain't gonna happen here. These rules do not allow for what you call ambush. A key objective of the rules is to banish any such possibility. These rules emphasize everybody's cards on the table from even before litigation begins, if you have pre-action protocols, so that from the very inception, everybody has their cards on the table. And that renders the trial process more efficient and shorter. One of the most dramatic consequences of witness statements is that it shortens the trial by maybe 35% of the time or more, because it renders examinations in chief more about fairness and justice and less about memory contests and skillful advocacy. Examination in chief used to be about the skill and artistry of a lawyer being able to tease out the evidence in chief from a witness without leading the witness, because the minute you start leading the witness, objection, my lord, comes to leading. it used to be about a memory contest. The witness had to go in the box and remember all the things that had happened to them 4, 5, 6, 7 years ago, and rely on the lawyer to jog that memory in a way that didn't accuse you, didn't leave you open to the charge that you are leading the witness. And if the witness couldn't remember, or if the lawyer didn't have the skill to jog the memory without being accused of leading, then the evidence just didn't get in. That's not justice. That does not promote the overriding objective. Witness statements actually enhance. I remember one of the lawyers coming to me because he was very disappointed that artistry that was involved in teasing out evidence and without being accused of leading the witness, that because the rules had now banished that, he felt that, you know, that was a loss to the profession, to advocacy skills. I said to him, no, witness statements actually enhance advocacy skills because it deploys those skills to enhancing the vital pursuit of truth. The reason why we have in our system, why our system is adversarial, is because that is our method for being able to get at the truth, to allow for cross-examination to take place. Witness statements allow cross-examination to be more effective because you are able to know exactly what the witness is going to be saying. You're not going to have any surprises. So you can prepare your cross-examination. You could deploy Paul Drake on that witness statement before you get into court, so that when you cross-examine, you will be very detailed, you'll be very incisive, because you know precisely what you're attacking. You're not hearing it for the first time. And therefore, your cross-examination is going to be a lot more effective. Witness statements, yes?
Let you know the halfway mark is here.
Okay, good. The witness statements also contribute to the fair and expeditious disposal of the proceedings, saves costs, promotes settlements, and so on. So we could go to the fourth slide, I think it is. So you could skip that slide. You'll get these slides, and there isn't much further to say here. We've dealt with this slide already. Next slide. Good. So suppose you can't get, normally at the case management conference, the judge would say, witness statements must be exchanged by the 15th of April. But your witness is overseas, or your witness is in the hospital, or you simply cannot get that witness statement either to have it recorded, prepared, or to have it signed by the 15th of April. What can you do? Well, the rules make provision for you to file a witness summary. What's a witness summary? A witness summary is a succinct summary of what the witness was going to say, what the likely evidence that the witness would be saying at trial. And the lawyer can prepare that in the lawyer's own words, in the lawyer's own, the lawyer prepares that himself, and you simply file that almost as a holding situation, because the rules permit it. You allow the other side the opportunity to know what it is, what is the evidence that the other side is going to be faced with. And in the meantime, before the trial, of course, you buy yourself some time to get the witness statement signed by, prepared and signed by the other side. When the judge gives the order that the witness statements are to be exchanged by a particular time, can you call up your friend and say, hey, Connie, can you get me till the next one to file my witness statement in Berridge versus Simpson? And your learned friend says, well, you know, it's good that you call because that other case that we have, I am going to be a little late with my witness statement as well. So, you know, let's extend our time. You can't do that. The rules cut out that kind of horse trading behind the court's back. In fact, Part 26.7 specifically states that if an order requires a party to do something by a specified date and specifies the consequences of failure to comply, and invariably, when the court makes the order for simultaneous exchange of witness statements and for witness statements to stand as evidence in chief, the court may very well and often will also say that failure to file a witness statement means that you wouldn't be able to give evidence at the trial. And if the court said that at an order, then you can't circumvent that order by agreement with the other side. You could ask for an extension of time to serve the witness statement, and the court would usually grant that extension provided the trial date is not compromised. Under the rules, adjourning a trial is a mortal sin. The rules absolutely frown upon any application to adjourn a trial. Venial sins, well, the rules provide mechanisms for appropriate absolution. And we would give you some cases where the court allowed for witness statements to be, the time for witness statements to be exchanged, to be extended. Next slide. If you're ready to serve your witness statement, but the other side is not, and they had said exchange must take place on the 15th of April, where one of the things that you can do is to file your witness statement in a sealed envelope and give notice that you have filed it. Because the whole idea of simultaneous exchange is that the court doesn't want that the defendant, if you're the claimant, for example, and you're ready to file your witness statement, that the defendant should be seeing your evidence and tailor their witness statement in order to respond to your evidence. So you can file your evidence, your witness statement in a sealed envelope and give notice that you filed it. The court office mustn't disclose it to the other side. Next slide. The witness statement, as I said, it usually is treated as the evidence in chief. You go up, you say, my name is John Brown. Yes, I signed a witness statement. This is my witness statement. That's my signature. And I wish that to be regarded as my evidence in chief. And you're up for cross-examination. If you have not filed a witness statement within the specified time, then you have no evidence in the case, even if the witness is there in the well of the court, sitting down, ready and willing to give the evidence, even if the witness is the claimant or the defendant. If you don't file your witness statement, then you have no evidence. And the court cannot give permission at the trial unless you had a good reason for not previously seeking relief. A witness statement may be amplified at trial, and there are a lot of cases on that because there is this tension between what is amplification and what is actually production of new material. There are cases that set out some of the principles, but in principle, you can, while you can ask to amplify, you can't introduce new material. New matters may be adduced orally only if the court permits and the matters have arisen since the service of the witness statement. The court may also grant the witness permission to comment orally on an opponent's evidence. So usually a trial is all about cross-examination and re-examination. And because you have eliminated all of that sometimes very difficult process of eliciting the examination in chief, you would find that this approach cuts down trials. A 2-day trial immediately becomes a 1-day trial. A 1-day trial could be heard in 2 or 3 hours. And it is a great, it helps to get the cases through the system. As I said earlier, the court may also order in particular cases that evidence can be given by affidavit, but that is usually for those instances where there isn't a lot of dispute of fact. Evidence that is contained in plans or photographs or so, you can simply indicate your intention to adduce such evidence. You must give the court your intention to adduce that evidence. The latest date for disclosure is the latest date for serving the witness evidence. And if there isn't an order for witness statements, then you must disclose that you wish to produce plans or images, photographs, at least 21 days before the hearing of the matter. So that is a very succinct sort of summary on witness statements. And if there are any questions, then we'll be happy to treat with them. Of course, we would give you, and there was I was looking in my files and I found a paper that I prepared specifically on witness statements in 2007. And we will include that in the bundle that we will provide for you.
So this time we're happy to have, we've covered for this evening, commencement of proceedings, the 3 ways. We've identified the differences between fixate claim form, standard claim form, fixate claim form, and originating applications. And we've tried to say that relevant to these are the application of performance standards. And so Dennis has mapped that, I think, reasonably clearly for all of us. Then we looked at evidence management and how that is relevant to both settlement and disposition of matters. And now latterly, we have considered how witness statements are central to the effective and efficient hearing, settlement, and disposition of matters. In all of this, we've tried to apply the overriding objective and as well to explain some of the details in the rules. You would recall that Sir Dennis took great pains to say, look at the details when it comes to, for example, things like service within the jurisdiction, service out of the jurisdiction, because the rules are very detailed on that.
Justice Chairman, I see it.
Sure.
A question in the chat. How does filing a witness statement in a sealed envelope work in practice? Excellent question. I've seen it happen just once. What you do, you go to the court office, you file the witness statement, you go with an envelope, you then fold it, it's filed, so that it can establish that on the 15th of April, when it should have been filed, it was in fact filed, and you put it in this sealed envelope, and envelope could be marked witness statement in Berridge versus Simpson. And it remains there because we don't want the other side to have sight of it until and unless the other side files their witness statement. So the court office will have to manage that situation in that fashion.
If I might
One
add
more
something.
question in the chat. How
Could I
is
add something to that answer?
Sure,
please?
sorry, Dennis.
The fear of it being impractical. This is not the only situation. The court has a power on application to order other types of material on the court file. to be kept confidential and not available for public disclosure. So the court, I'm trying to find the rule now. I don't know if you can find that. I think it's in rule 5, 3, part 3. Anyway, but wherever it is. So there are other circumstances in the rules where the court is required to ensure that material on the case file is not available to public public inspection. So there is the court has to develop specific programs to accomplish this.
But I think we can all share our experiences that this is something that is relatively routine, in the sense that in all the jurisdictions this occurrence happens and is dealt with. And this is a standard way. You take the document, it's stamped, put in the envelope, sealed, a note is made, and it's, as Sir Dennis said, kept confidential and safe until a court directs what is to be done. Larissa, you said there was another question?
Yes, Judge. The question is, how are witness statements from a blind person addressed?
Sorry, I didn't get that.
How are witness statements from a blind person addressed?
Well, the person can simply give you the instructions, and in the same way that you deal with an affidavit by a blind person, there's a special jurat, I think, and you probably have to get a justice of peace or a notary public or the registrar to certify that this person has signed it. But the same rules that would apply to the execution of documents by a blind person would also apply. What's important is that you capture what the witness has to say, and you have, apply those rules for the witness to sign that statement, or to have his or her statement signature affixed, and have it served on the other side.
Just allow me to interpose something here, following up on what Sir Dennis said. The rule I believe that you were referring to about inspecting the file is Rule 3.10, I think it is. If those who are listening are interested. I can't share my screen unless I would do so. But you have it.
Yeah.
I think this might be the rule you were talking about, where it says that on a prescribed fee, you can have access to the file with redactions if necessary, but only these particular documents, which are pleadings, defense, a reply, or what's called a statement of case in the new rules. Just a plain form of reply and notice of appeal and a judgment, and then you'll see F with the leave of the court, which may be granted on application made without notice. So the access, public access to the documents is somewhat restricted. So I don't know if that's what you had in mind, Sir Dennis, but I thought I would just mention.
That was part of it. I think there was a rule before that where parties could apply to the court for documents to be confidential.
Oh, you mean to make it confidential?
Yes, and the court has the power to make an order for the matter to be confidential.
Right. Okay.
So that was an additional power.
You go ahead. I'll see if I can find it in the meantime.
Yes. Actually, I stopped looking for the rule, but I'm actually starting to look again.
There's another question in the chat about the attachment of documents to a statement of claim. Don't consider attachment there necessarily as physical, but it could mean also simultaneous filing with the statement of claim, so that that the documents, however voluminous, should be simultaneously filed with your claim form.
I think the rule, President, if I'm not wrong, may talk about identification. I think the rule.
That's true.
Yeah,
Yes.
I think
Yes.
the rule says that you must identify all documents that are relevant or you intend to rely on. So
right.
you don't have to physically attach everything, but you must identify it. And then,
That's
of
right.
course, having identified it at a first case management conference, standard disclosure or specific disclosure can apply to say, make it available for inspection and copying. And there's a practical reason for that, which is, of course, that in some matters, you're going to have hundreds or thousands of documents. So you don't want to have a claim form that's, so, and I know that, for example, in Trinidad, some of the litigation is quite voluminous. They would actually do an appendix, which is a sort of like the old-time list of documents, and you identify the documents in a list where there are a lot of documents. But yeah. Are there any other questions, Larissa?
Not that I am seeing. One comment saying excellent advancements. I'm seeing one question in the chat, but I may have been answered already. How can a witness statement in an envelope be filed electronically? It's from two different persons, so it may have been answered.
Yes. Yeah. Well, maybe President Sir Dennis, how do we want to close off? I think I've said my little bit, so.
Well, I could the thought that's in my mind, right, as we are coming to a close, is the way in which all of the rules governing the processes of the court seem in several ways to implement the overriding objective. And I think each of us have demonstrated, each time we have done any aspect of these rules, that we always start with the overriding objective. So I think the important takeaway is that the overriding objective is I suppose the basis for the cultural change that observing the CPR requires, and that everything that we do must further the overriding objective. And as I said in certain other cases in relation to case management, that this is really a team sport, because all of the parties to the litigation have to combine in different ways in furthering the exercise of the overriding objective. And as you looked at the caretaking in the regulations, how proceedings are commenced, you see how the rules have taken great care to ensure that the defendants are put on an even footing. They don't have to go to lawyers if they don't want to, because they can, on the acknowledgement of service, state very simply and clearly what their position is. And the court is assisted in doing its job by requiring the parties to outline their cases so that issues can be identified early, and so on and so on. So I suppose the main takeaway for me was the emphasizing that one always starts with the overriding objective.
Yeah, I think that's something that we've all learned in the use of the rules. That's the key that unlocks the whole new culture. I'll pass on to the president, but just to give a nuance on Sir Dennis, he talks about a team sport. I agree with that, but I don't want us to lose the fact that in this team, there is a clearly identified and mandated leader, President.
Yes.
Yes.
I accept that.
I want to take off where Sir Dennis left off, because you would hear us every session. There will not be a session that we have where we don't mention the centrality and importance of the overriding objective. But there's a little caution I wanted to introduce, and it is this. the overriding objective, which speaks about having cases dealt with justly, it doesn't mean that you could intentionally flout the rules and stand up before the judge and say, well, I have a good case. How could you just have this case go down the drain? Overriding objective. The overriding objective itself means that you must adhere to the rules. So you can't flout the rules and then plead overriding objective. So help me out here, sir. Help me out. You know, that is a contradiction in terms. So that one has to be careful that one understands the overriding objective to be a principle that the court utilizes when interpreting and applying the rules, and not a substitute for the rules themselves, because the very rules incorporate the advancement of the overriding objective. So I just wanted to emphasize that.
And President, just to ground that in a rule, for those who want to check it, 1.12F, dealing justly includes F, enforcing compliance with rules, practice, directions, and orders. So that balance is not something that we are introducing in some sort of philosophical way. That's in the text of the rule as one consideration that is central to this idea of dealing justly, rule compliance. And I think that's why President and Sir Dennis, at the very beginning, we spoke about the idea of procedural justice. Justice according to the rules is justice.
Yes, I just want to take up one last question that I see here. Do the timelines apply to all matters irrespective of the complexity of the matter? And this is where you come back to the overriding objective. The rules are not a beast. The rules are not intended to stymie anybody. The rules are really intended for litigation to proceed in a responsible and effective, efficient manner. If the matter is complex, then the rules allow for appropriate measures to be taken to address that kind of complexity. Applications can be made to extend time. Applications can be made to allow for the complexity to be taken into account in whatever way. What the rules don't allow is for you to think, have in your head that, well, this is a complex matter, so I wouldn't bother to, I can't do something by the prescribed date because it's too complex. And behind the back of the court, you take it upon yourself to give yourself an extension of time. You can't do that. The court, nor can you, as I gave the example, conspire with the lawyers on the other side to get around the critical provisions in the rules, particularly those that relate to the timing of important milestones. What are important milestones? Case management conference dates. That's an important milestone. And the most important milestone is the trial date. You can't say, well, my friend and I have agreed that that trial that was set down for the 15th of June, given that his witness fell sick and blah, 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 we would like the court to, no. You can't proceed like that. You have to comply with the rules. You have to apply for relief from sanctions early if it is that through some inadvertence or something beyond your control, you were unable to comply. You have to relate to the court in order to get the court's blessings for any kind of step that you feel that you would like to take in order to present your case properly. The rules are court-driven and no longer lawyer-driven.
So on that note, Sir Brian, so Dennis, you wanted to add anything before we close, or you're okay?
No. I'm happy to bow to Sir Brian.
Yeah. So Brian, we leave it to you to close this evening session.
Thank you very much. And again, you have given us a very clear and engaging and informative session dealing with these rules based upon your extensive experience. I must say that all of the feedback that we're getting on the sessions have been very positive. And in that regard, I would invite you to complete the questionnaire that will be circulated with regard to the session today. So that helps our panelists and indeed the organizers of these sessions to be responsive and to improve them as we go along. We still have a lot of sessions ahead of us. We have a total of 15 sessions altogether. Let me remind you, please, that the next CPR training session is scheduled for the 23rd of March from 4:30 to 7 p.m. The schedule has been circulated, so hopefully you have it. If you don't have it and you would wish to have it, just send a note to the registrar or to my office and we'll make sure you get it. But it was circulated through the bar. And please note in your diary, the 23rd of March at 4:30 is our next session. So again, I would wish to convey my gratitude and the gratitude of all of us to Sir Dennis and to Justice Saunders and to Justice Jamadar for a great job and for taking us through these rules. And I believe that everyone is beginning to connect the dots and to see not only the technical requirements of the rules, but to get a sense of the culture behind the rules and the paradigm shift that we will have to make if we're going to get the full benefit of these rules. And I might say, Sir Dennis and Justice Saunders and Justice Jamadar, your personal reflections and experience in applying these rules brings an immense sense of practicality to the exercise, because through these experiences that you're able to relate to us, the rules do come off the page and they become living, and we see how they are applied, and that's based upon your extensive experience. So thank you very much again for that. And I wish to thank all of you who have joined us. I think at the peak of the session, we had 156 participants today. So that's a pretty good turnout. I thank the members of the bar and everybody else. And I would wish you all a very good evening. So thank you and good night.
Yeah, okay, good night.
Thank you. Thank you. Good night.
By the way, sorry, let me just say, just to remind you before we all sign off, today's session has been recorded and it will be posted on our website. I want to remind you that all of the sessions are currently on our website, with the exception of the last one, and that's going to be going up tomorrow. So there's a good resource library that we're building here. All of the PowerPoint slides that the Casio team has used are on our website. All of the sessions, the recordings are on our website. The session that I did last week with Crystal Roll is on our website, or will be. And today's session will be posted on our website by tomorrow evening. So take advantage of it. If you have friends or colleagues who are not able to join us, please ask them to go to the website. It's very easy. There's a special button that deals with the civil procedure rules. Click on it. It takes you right to the page, and it's a simple click. I tried it. It takes 3 clicks, and you can listen to the entire session. I would encourage you to do that. Use it as a resource, and that'll help us going forward. Again, thank you and good night.
Good night.
Good night, everyone. Bye.
Good night, everybody.